Bhai?
Yes, already.
Now we are playing ICI motto song. I request all the participants to put their right hand on their heart.
येष सुप्तेषु जाग्रति येष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Good morning, all friends. As we all are standing with proud before or amongst all the branches of India, even the member of CA Institute Ahmedabad branch feel happy and proud amongst all the members of India, and it is due to only one person, that is Chairman CA Fenil Shah sir. So I now request CA Fenil Shah sir to give his opening remarks. Thank you.
Thank you, Bishan Bhai, for giving a wonderful start to this morning session. But I'd just like to correct that it's not because of me, but it's because of whole team and the efforts of everyone cohesively and collectively that today Ahmedabad branch was adjudged as best branch all over India, both in the members section and also in the students section. With this, thank you. Senior Advocate Navin Ji, Advocate Jaymin ji, PCS Vinodkumar ji, and also one learned speaker, Senior Advocate Tushar Hemani ji. The speakers for today's sessions, C. Anjali Choksi, the Managing Committee member and the curator of this whole one-day seminar, C. Vikas Jain, Regional Council member, and C. Bishan Shah, the Secretary of Branch, and dear friends from profession and young members, I take an immense pleasure to welcome you all to this one-day seminar where we are going to discuss the opportunities which are emerging in the legal sector for a chartered accountant. How good it is that when other professionals are discussing on negative things, that is why GST taken away, why tax audit limits have been increased, due to technology, the scope of chartered accountants is reducing. We too agree with that. But we cannot do anything with respect to that. Yes, ICI at their level are doing all representations. You might have seen all the news to department that why GST audit should not be deleted. And they are trying their best to ensure that our interest is not affected. But at that point of time, what we can do is, instead of commenting on social media and doing wrong things, we can do is, which is in our hands, that is to improve on our skills and to develop more opportunities for us. And in that line, opportunities in legal sector is very good. And with that intention, we curated this particular one-day seminar focusing more on litigations and advisory. Friends, before Anjali Ben takes over, I would also like to invite you to join on various one-day sessions, 2-hour sessions, which are going to come in the field of GST and income tax. Apart from that, on 18, 19, 20th, that is the next weekend, we are having the RRC at Jaisalmer on opportunities again. You can join that also. And apart from that, on 21st of February, we are having a cyclothon in the morning. So if you wish, you can join with all the family members. With this brief words, again, I thank all the speakers for joining this particular seminar. Thank you. And now hand over to Anjali Choksi.
Thank you, Chairman, for always inspiring us. Secretary CA Bishan Shah, RCM CA Vikas Jain. What the Chairman mentioned is very much correct. With the new normal, we have witnessed the power of digitization. And it has also been reiterated in the union budget, the first paperless union budget, that our profession is shifting towards consultancy vis-a-vis compliance practices. And hence, the Ahmedabad branch of ICI is relooking at the profession and trying to explore the new and emerging areas of practice. And today's seminar is exploring these opportunities in the legal field, in the law field. And accordingly, various experts from this field have been selected. We are privileged and fortunate to have Senior Advocate Pavaji with us in the first session itself. And accordingly, the topics have been selected, whether it is drafting of notice, minutes, filing the application, physical appearance before NCLT, and hence, before a company or a CIRP is admitted, what are the safeguards, or what is there in the client interest which we need to do and guide our clients will be taken in the first session by Pavaji. Now, before I introduced Senior Advocate Pavaji, I would also request CA Vikas Jain, who is also a curator of this series, to share a few words with us, and then I'll introduce and we take the session further. Thank you so much. Vikas Bhai, over to you.
Thank you, Anjali Ben. Today's guest, today's speaker, learned Senior Counsel Sri Navin Patwa sir, Chairman of the branch Fenil Bhai, Secretary Bishan Bhai, Managing Committee Member and Vikasa Chairman C. Anjali Ben, seniors in the profession, my dear friends, a very good morning to all of you. Friends, we all are going through a turbulent time, I would say. Firstly, it was on account of the pandemic, and which has taken a big toll on the economy and many other things. But see, we all understand that whatever happens, maybe I won't say that it happens for a good, but that always brings opportunity with its fold. And we have seen that after the slowdown in the economy, now the economy has bounced back with double the speed, I would say, in most of the sectors. And even if we see the share market and all these things, the kind of the growth that is being reflected over there. And whenever we sit with our client and we discuss the things, most of the clients are saying that the activities are increasing like anything. So friends, the turbulent time always brings opportunity. And here also in the budget, this has been a turbulent time, I would say, for the members. We have been thinking a lot on this because of the two main areas of activity that includes GST and income tax. But for the last 2.5 years, I have always been saying this and reiterating on every forum that friends, may it be because of budget or whatever it is, but in the times to come, the compliance practice is going to die away. That is for sure. We have to be future ready. We must prepare ourselves for the things. Undoubtedly, our institute is trying its level best that these two provisions are dropped from the budget and the position before that is restated, so that the bread and butter of the most of the chartered accountants, and we understand that especially for the people from the rural areas or the urban areas and the new practicing professionals, this is very, very important for the survival also. So institute is taking it very seriously. We had a talk with the Central Council members the day before. They also met Honorable FM Nirmala Sitharamanji. But having said so, we all must be future ready. We need to understand that the way the technology is affecting our lives, undoubtedly it is doing so many good things to us. So in the times to come, all these return filing and all these things are for sure bound to go away. So we need to do something different, and that is the reason with which we have thought of this particular series. And legal profession is something which is very, very promising, I would say. One is legal and another is technology. These are the two professions that seems to be most promising in the times to come. And we being chartered accountants, we are having both the I would say exposure to both these areas, legal as well as information technology. And if these combo, the knowledge on these combo is going to help us. I've seen that so many senior professionals like that of Vidhan Surana sir, Mukesh Trivedi sir, all these are also attending this seminar. So they understand that the kind of seminar this is, and the faculties, these are the best of the faculties, I would say. Navin Patwa sir is always a pleasure to listen to. And this is unfortunate that after a long time we thought that we'll be able to see or hear in person, but because of the so many restrictions and compulsions, we have to arrange this in the virtual mode. Otherwise it would have been a great time, and we have met so many friends after a long time. But with these introductory remarks, I would now request Anjali Ben to take this program further, and I wish you all a very happy learning. Thank you very much.
Thank you, Vikas Bhai, for sharing words of wisdom. And our RCM always motivates us. Thank you so much. Now, without taking much time, it's my privilege and pleasure to introduce Senior Advocate Navin Kumar Pawaji. He's a senior advocate from 29 September 2017, a bachelor in commerce and law from University of Delhi. He's also the fellow member of ICSI and he's practicing in High Court since 1993. I have heard him in NCLT and it's really a privilege to listen to him. And I'm sure all my members will also love to listen to him. He has been practicing in High Court of Gujarat, Supreme Court, and before NCLT with matters related to IBC and Companies Act. He's also appearing before referred forums in matters on different subjects, including corporate and commercial laws, banking and security laws, insolvency laws, maritime matters, tender, contract matters, and arbitrations. You also advise on various issues, including the compliances under the Companies Act, SEBI, electricity laws, banking and securities laws, and IPR. So without taking much time, my all words would not be enough to introduce him. So I am very curious to listen to him. And with these words, I would now request Senior Advocate Pawaji to take the session ahead. Thank you so much.
Very good morning to all of you.
Very good morning, sir.
Fenil Bhai, Anjali Ben, Bishan Bhai, Vidhan Bhai, I can see him, and other friends who are listening this morning. It's a pleasure to be associated with your institute and with all of you. The course of Chartered Accountancy is always an enviable course. If I go back by about 30-40 years, I would have always remembered that any person who wants to become a professional on the commerce side, he would like to become a chartered accountant. So I really acknowledge that all of you have successfully crossed the hurdle of acquiring the distinction of being a chartered accountant. And that's of course only through your hard work and perseverance that you have all achieved this basic qualification. Having said that, see, what is legal profession about? I must take a few minutes before I go to the topic which we are discussing this morning. Is this that legal profession is all about hard work. And second aspect is the common sense. You all guys have worked very hard and you are still working hard. You all have also a good common sense. And because of your qualification and your experience, your common sense is also must have sharpened to a great extent. Therefore, for members of your institute to practice on the legal side is not a difficult task. I would always suggest that you guys should take plunge into the legal profession to the extent permissible. NCLT has opened up that door for practicing professionals from your institute and other institutes to also practice alongside the lawyers. I must say that I have noticed many professionals, both for your institute and from the Institute of Company Secretaries, who are doing extremely well in the profession before the NCLT. So this session today, I would devote, besides the topic that we'll discuss, my another object is to encourage all of you to come forward and take up the legal profession as your primary profession of practice and for your, of course, success in the career. Having said that, we'll go to the topic of the today. The topic says legal aspects and consequences safeguarding client interest in pre-petition stage. My endeavor would be to touch some aspects of IBC and the Companies Act. And in that context, I would make some suggestions which you will like to consider. Now, before we examine what safeguards you have to advise to the client at the pre-petition stage, of course, you are expected to know about what the law is about, which we're talking about. So in today's session, I would touch briefly about the basis, the law, the subject, what's it about, what are the issues which normally come up, and the relevant safeguards which one must keep in mind as a professional such as you, who can advise the clients at the pre-petition stage. To begin with, we'll touch some aspects of the IBC, and in the later part, we'll touch some aspects of the Companies Act. We go to the next slide. Now, see, IBC is a corporate insolvency resolution process. Unlike the Companies Act of 1956, where we were concerned essentially with the process of winding up of the companies in the event of defaults being committed, where one could approach the High Court to seek an action for winding up. The IBC provides for resolution of the corporate debtor. In fact, as per the views expressed by various judicial pronouncements, IBC is not to wind up the corporate debtor. IBC is all about bringing about a corporate insolvency resolution. The whole process is to bring about resolution of the corporate debtor. So the preamble is just for your reference. The preamble talks about the laws which relate to reorganization and insolvency resolution of the corporate persons. Partnership firms so far, of course, is not implemented, but is going to come. Then insolvency resolution of the individuals in a time-bound manner with a view to maximize the value of the assets of all the concerned persons, etc., etc. Next. Now, with this intention, the IBC came to be introduced. It talks about the resolution of the corporate person which has suffered the insolvency through a mechanism by which a resolution applicant takes over the corporate debtor and maintains the concept of going concern. One thing we all should remember is that the whole object of the IBC is to maintain the concept of going concern. Therefore, when you want to advise the clients, a client which is suffering some insolvency issues, you may consider to advise the client that it must take the approach through the NCLT under the IBC for its resolution. The whole object, I must tell you that this IBC is one of the most positive enactment which is brought into force in the direction of bringing about real resolution of the corporate debtors, corporate persons. Hitherto, as I mentioned, I have not come across any law which works towards the interest of the corporate debtor and its resolution. This entire statute is to bring about a resolution of the corporate debtor. Now, therefore, the whole mechanism is worked out in such a manner that you bring about a resolution applicant, which could be even the corporate debtor also, provided it is not ineligible under the scheme of the code, to submit a resolution plan, which once is approved by the committee of creditors, is ultimately takes into a shape of a resolution plan to revive the company as a going concern. You are avoiding the process of liquidation. If, of course, despite all efforts, resolution is not brought about, then one has to go to liquidation. It is also said, as per various judicial pronouncements, that the CIRP process is not a recovery mechanism. You are not going to the NCLT under the IBC to recover. So therefore, if some client comes to you that we have to recover X money or Y money, and therefore I will take action against the corporate debtor, seemingly the answer is no, because the object is not really the recovery. If the NCLT is of the opinion that you have come only to recover and the intention is not to bring about a resolution of the corporate debtor, NCLT has a right to refuse your application. Although in practice, of course, if you have to recover, you initiate the action, and if the debtor is unable to settle the dues, it goes to the process of resolution, or vice versa. If it doesn't want to go through the process of resolution process, it pays your debt and you withdraw the proceedings. But as a matter of practice, the NCLT does not appreciate a person who comes solely with the intent to recover dues from the corporate debtor. Next. Now, this is just some basic ingredients. There is a law which defines the corporate debtor. Initiation of CIRP is under three ways. One is section 7, 9, and 10. 7 is at the instance of the financial creditor. 9 is at the instance of the operational creditor, and 10 is by the corporate person itself. I must say at this stage that 7 and 9, is something which is perforced on the corporate debtor. They have to face, as a respondent company, an action under section 7 or section 9. But 10 is an act which the corporate person on its own can initiate by going to the NCLT. So it was like this. If the corporate debtor whom you are advising is facing financial issues, insolvency issues, defaults, which apparently are causing prejudice to the company, its functioning, etc., you may advise the corporate person, the company, and it may consider to move the NCLT for its own corporate resolution. So if you advise so and they agree, there's a process under section 10, which I'll discuss a little later, for applying which you can move the NCLT and seek your own resolution. The whole concept of resolution is extremely well made, well defined, and prescribed in the law. And in no less than 6 months to 1 year, you are able to achieve your own resolution. Next. Now, this is the first kind of initiation, which is the initiation at the instance of a financial creditor. Now, financial creditor, as we normally in our parlance as commerce professionals have so far understood that an FC would mean a secured financial creditor, a banker, or a financial institution. But it is not restricted to only banks or financial institutions. A financial creditor could be any person, could be an individual, could be a non-banking institution, could be a non-financial institution. Any person who has financed, advanced money to a company, along with a consideration that the money would come back someday with interest, that person becomes a financial creditor. So please consider the scheme of the IBC, which defines FC, is different than the scheme of SURFACE or RDDB or Banking Regulation Act or the Companies Act. So here, any person who has advanced any financial assistance, disbursed money to the company with a consideration that you'll get the money back with interest, with, in our parlance, as a lawyer or as a litigating professional, we understand as a time value for consideration. Any money disbursed with time value for consideration, where meaning is that with passage of time, your money grows. The consideration is received by you over and above the amount advanced to the corporate debtor. So if that kind of arrangement is worked out, you become a financial creditor. So you come across a person who has advanced some money, could be an individual, could be a partnership firm, and may not be a bank, as I said, may not be a financial institution. If he qualifies these ingredients, that person under the IBC is a financial creditor. Now, this financial creditor, if he or it is entitled to recover an amount of more than 1 crore, and the debtor, the company, is in default in making payment of such an amount, then this financial creditor is entitled under the IBC to initiate action and seek the resolution of the corporate debtor. This is all about it. Now, see, Limitation Act is brought into force in the IBC. Hitherto it wasn't there. By some amendment, a provision has been inserted whereby Limitation Act is inserted in the IBC, which implies that you must initiate the action. You means any person, could be a financial creditor or an operational creditor or even the corporate person itself. The action must be initiated within a period of 3 years. So from date of default, within 3 years, you must initiate the action. Therefore, suppose someone comes to you with an advice, look, Mr. CA, I have this money to recover against so and so person. You must first ascertain whether the person who has come to you is a financial creditor or an operational creditor. Depending upon the status, then further action has to be initiated. At the same time, you must also inquire whether default actually has occurred. If not occurred, you can't initiate the action. There has to be a default, and then only you can initiate the action. A situation normally emerges in most times is about persons having extended financial assistance to the corporate debtor in the form of unsecured loan. I have come across a large number of persons, could be even the company's directors, company shareholders, third parties, their relatives, having advanced financial assistance in the form of unsecured loan to the company. Now, there has been no practice, which I understand is prevalent, for having executed an agreement under which the loan is extended to the company. So what happens is some loan is given to the company, no period is defined of repayment. Sometimes you don't even provide for a stipulation with regard to payment of interest by the company. Company sometimes pays interest, sometimes doesn't pay interest. What happens whether the person who has given that money as unsecured loan, can it be said to be a financial creditor or not? And at what stage the default is deemed to have happened? These are the questions which come up very frequently before the NCLT. Now, therefore, in that context, you as professional should know as to what kind of questions you need to ask from the client. Now, the answer is that for disbursement of money by a person to the company, necessarily or by implication, an agreement should exist. Now, if agreements are not made, then possibly you may refer to some correspondence, some email communications to make out or demonstrate that there was some stipulation, there was some agreed arrangement or agreed understanding between the parties whereby the money given as unsecured loan to the company had to be repaid back to the concerned gentleman within a defined period. You must also establish an understanding that the money had to be repaid back along with some element of interest. Some return has to come back. Now, if these stipulations don't exist, there are judgments which have taken the view that you can't claim the status of a financial creditor because there is no time value for consideration. So with passage of time, if you are not entitled to receive interest, a return on the amount that you have given to the company, then you are not a financial creditor. So please understand this definition, as I mentioned to you, is completely different as what we have discussed in our CA course, could be under the SURFACE or Companies Act and other statutes. Here is very important that not only the money has been given, but there is an understanding or an agreement whereby the money has to come back in a defined period along with interest. Therefore, in a given situation where a client comes to you and he talks about this unsecured loan having been given to the company and money is not coming back, what to do? So the advice which normally you may like to give is that if agreements are not executed and you still have the opportunity, you must insist and get an agreement executed even now. Two, you must also consider to have some kind of arrangement whereby interest element is stipulated or agreed upon. If not done so far, you may have some arrangement which can be recorded in some communication, if not a properly executed agreement. Third is that assuming that you are able to achieve this process of an agreement or a contract or some email communication, these things are accepted. What happens to demonstrate default? How do you show that default is committed? Now, for this, you have to give, suppose the law is, if suppose you are given unsecured loan without a defined period of repayment, the law is that you have to give a notice and call upon the person concerned to repay the loan back to you. Once you give a notice and the amount is not repaid back to you, the default is deemed to have occurred, right? So this process of issuance of notice is must. So if you are wanting to file a petition as a financial creditor, you must take into consideration these aspects, namely that if it's unsecured loan, without any stipulations, please consider to have some stipulations executed if possible, or if not, at least some email correspondence by which you accept, or you have some document from the other side, from the company, in your favor. And third, if there's no stipulation about the repayment part, you at least have a notice sent demanding the money, and a period be stipulated in the notice, in default of which the default is deemed to have occurred for the purpose of IBC, after which you can file an application under Section 7 of the IBC. Next. Now, because of this lockdown, COVID, etc., there is an amendment in the IBC which has stipulated that for any default between 25th of March 2020 and now 31st of March 2021, you can't initiate any action under the IBC, be it as FC or OC or any other person. So for this default, this period between 25th of March and 31st of March, your right to initiate action under the IBC is ousted. Barring that period, if a default exists before this date of 25th of March or after 31st of March, you can initiate action under the IBC. Now, see, the format of the petition is prescribed under the IBC. It is for the purpose of Section 7, we have, I think, Form 1. So Form 1 provides for some details to be provided. You have to make sure that those details are properly filled up, and the requirements of documents which are to be appended to the application are given in the rules. So rules has to be seen by you, and please accordingly see that the application is complete, because the law is that if the application is not complete, the NCLT is required to reject your application. That is the stipulation of law, mandate of law. So therefore, the application has to be complete as provided in the IBC, read with the rules. So you have to consider to refer to the rules which provide for certain documents to be supplied along with the application to have it complete. Now, therefore, I said Form 1 is what has to be seen, and the requirements of the application has to be fulfilled before you initiate the action. Basically, if you are filing an application as an FC, if you're advising a client to file an application who is an FC, some documents, as I mentioned to you briefly earlier, are necessarily to be appended with the application, and those are the financial contracts. That could be a loan agreement, could be just an agreement, could be a MOU, could be assignment deed, a facility agreement, or any other document which establishes the arrangement of disbursement of money from you to the company, and also a stipulation that the money has to be returned back to you, repaid back to you along with interest. So this document, the contract, as I said, is very, very crucial. It is a must. If we have not done in past and you are advising clients for future arrangement with the corporate debtors, the companies, please consider to advise the clients that even for giving unsecured loan to the company, even by a person who could be a director of the company, kindly see to it that you have an agreement in place as per the stipulations of the IBC. Now, additionally, there's a requirement to define the name of the interim resolution professional. See, I want to mention to you just at this stage, just to apprise you about the scheme of the IBC as to what happens once the petition is admitted. See, once the petition is admitted, you have filed Section 7 and the petition is admitted. What happens thereafter? As a professional, you should know. See, the NCLT would appoint a person who is insolvency professional. You are aware, I'm sure, that insolvency professionals are qualified persons who have to undergo some examination under the scheme of the IBC. And we have an authority known as IBBI. It's a board which grants the certificate to a person who qualifies as insolvency professionals. The NCLT appoints one of them as interim resolution professional. IRP is what is the short form of the person who is appointed by the NCLT, and this gentleman, by fiction of law, by fiction of the IBC, he would replace the management of the corporate debtor. So the board of the company is suspended and the IRP takes over the charge. So when you file an application, the application should also, along with the application, attach a form 2, which is giving the name of the proposed IRP. In the event the NCLT admits the petition, the gentleman is appointed by the NCLT as the professional who takes over the management of the corporate debtor. Now, the distinction, there's one distinction between the application at the instance of the FC and the OC. The distinction is, in case of FC, an application by the FC, you're not supposed to give any notice before you file a petition. You can file a petition directly in the NCLT. A lot of professionals sometimes ask me as to what steps you are required to take, because usually we have always understood as professionals that before I take any legal action against any person, there has to be a notice. So the petition should always proceed with a notice calling upon, demanding money, etc. The law is otherwise, so far as initiation of IBC at the instance of FC is concerned, and the law is you're not supposed to give any notice, nothing. If today you have a claim, you have a claim of money, so there's a debt and there's a default by the corporate debtor in the payment of the financial debt to you, you may straightaway file a petition before the NCLT and seek remedies as are constituted under the scheme of the IBC. Next, please. Next, please. Next slide, please. Yes, please. Now, see, these are the grounds on which the application under Section 7 is liable to be rejected. So we must know as professionals, because if you're advising a client who is a petitioner, he must not do any of these things which would entail a rejection of a petition. So one is the default has not occurred. As I mentioned to you, it is very important that you have to make out that default has occurred. Now, how do you make out a case that default has occurred? It's a banking transaction. We all are aware that as per the RBI regulations, if the account is classified as a non-performing asset, NPA, default is deemed to have occurred. So there's a fiction of law as is brought about on account of the RBI guidelines. So that by itself is sufficient to initiate action as a financial creditor before the Honorable NCLT. Now, over and above this, second is if there is no financial debt. As I mentioned to you, financial debt is defined in the statute. We have Section 8 of Section 5, subsection 8 of the IBC, which defines what is a financial debt. Now, financial debt, I would not go exhaustively to explain because that's something which you can always understand. But briefly speaking, there has to be a financial debt in respect of which you take the action. Financial debt is defined. So if you are advising a client who is a financial creditor, please kindly go through the provision carefully. And there are judgments which have discussed as to what is a financial debt and what is not a financial debt. So it is important that we must look at the definition and then advise the client accordingly about the financial debt or otherwise. If you are representing the interest of the corporate debtor and your client receives a notice, of course, again, you can look at the petition and examine whether the petition is filed at the instance of a financial creditor or the person is not a financial creditor. Third is that whether is barred by limitation. As I mentioned to you, limitation is now applicable to the IBC. So we all can understand that if it's barred by limitation, petition is not maintainable, whether you are a petitioner or the respondent. And as I mentioned to you, the limitation would start from date of default. So the date of default is, we have understood, could be the NPA in the routine parlance, or could be, suppose you have issued a recall notice and the amount has not been paid to you, the default occurs. So from date of default, 3 years is the period of limitation. If the action is not initiated within a period of 3 years from date of default, the claim becomes time barred and you can't maintain a petition under section 7 of the IBC. No express agreement, we have discussed. If you don't have a contract, there's a problem, because the law is that you need to have an agreement, more particularly because you need to have a stipulation about the repayment of the loan and a stipulation of the consideration of time value. So to establish these factors in a financial debt, an agreement is necessary, or in the alternative, at least email communications or any other kind of correspondence would be necessary to maintain your application before the NCLT. A petition has to be filed by an authorized person. A great importance is attached under the IBC to ensure that the petition is filed by authorized person. If you are a company, if the FC is a company, there has to be a person authorized by the board to maintain the application. So the authorization has to be attached with the application to maintain it. Of course, the law is, if suppose there is no authorization or the petition is not complete, the NCLT would give you an opportunity of 7 days to comply with those stipulations. If you so comply with those stipulations, the matter can be then addressed on the merits thereafter. And last is, if the proposed IRP that you have proposed, if is facing some disciplinary proceedings by the board, that is the IBBI, then also the petition is not maintainable. In which case, of course, remedy to you is you seek a replacement of the proposed IRP in the application by a person who is qualified otherwise, in which case the petition again becomes eligible to be taken up on merits. Next, please. Now, these are the two judgments by the Supreme Court, which I'm sure you must have gone through. Innovative was the first judgment which discusses the entire scheme of the IBC. And so the judgment has to be gone through. If any practicing professional of IBC, innovative is must read judgment. And so is the judgment in the matter of BK Education. BK Education judgment came after the provision with regard to Limitation Act came to be introduced in the statute book. Limitation Act, the question in the BK Education was as to whether the Limitation Act would apply even to pending proceedings, because the limitation was brought much later in the IBC, and the issue arose as to whether it would apply to pending applications also or not. The court says it would apply because it's procedural law. It applies retrospectively unless the intent is otherwise in the statute. So BK Education gives importance to application of the Limitation Act on the pending applications. These are the two judgments which are must-read judgments for all of us, and therefore a mention is made in this slide for your reference. Next, please. Now, as we discussed, Section 7 was one mode of initiation. Another mode is Section 9. Section 9 is at the instance of an operational creditor. Now, what is an operational creditor? OC is a person who has supplied goods or services to the corporate debtor. So that person becomes an operational creditor. And if the amount due to an operational creditor is not paid, that person can initiate action under the IBC. Now, before it initiates an action under the IBC, some things are necessary to be seen, and that are in the next slide. Next slide, please. Now, as I mentioned to you, unlike the case of FC, in case of OC, a demand notice has to be given. So if as an OC, your client wants to initiate action, suppose your client has to recover some money in respect of goods supplied to a company. So there has to be a demand notice. Somebody may have to mute the audio.
Hello.
Yes, please. So, as I mentioned to you, unlike in the case of FC, in case of OC, a demand notice has to be given. The demand notice again is a prescribed format is provided in the IBC. We have Form 3 or Form 4 for different situations. But in that form, you have to give a demand notice calling upon the corporate debtor to pay the amount to you. And within 10 days, the debtor company has to give its reply, either make the payment, or if they have some disputes to be conveyed to you, they can give a reply to you. So what is to be considered important is in this case is that if you are advising a client who is to recover, the demand notice is must. Demand notice has to be in a format given under the IBC. So please follow the format under the IBC. And along with demand notice, some documents are required to be appended, which is again defined in the statute. Please see Section 8, Section 9 of the IBC and the rules. So in compliance with those provisions of law and the rules, you have to give a demand notice. Wait for 10 days time. Within 10 days time, if you don't receive the payment demanded or any response, you can file a petition in Form 5 with the NCLT. So this is the process. If you are for the company, the corporate debtor, and your client receives a demand notice, that is very important that your reply should go within 10 days of receipt of the demand notice. The law is if you don't reply within 10 days, your right to reply is taken away. Of course, when the petition is filed, you can again reply before the NCLT. But if you don't demonstrate, suppose you have some dispute, a genuine dispute, qua the amount claimed by the person claiming to be the operational creator, and you don't raise the dispute, then a presumption is made out against you that you have no dispute. Of course, it's rebuttable in the course of hearing before the NCLT, but for some time, you lose the right to rebut the presumption. Therefore, it's very important that if you are for the company, the corporate debtor, you give a reply. If you have a dispute, a genuine dispute, you point out the dispute and tell the other side, look, gentlemen, the amount claimed by you is disputed because of ABC reasons. If you're able to demonstrate a pre-existing dispute in relation to the amount claimed by the operational creator, then as per law, the petition, any proceedings at the instance of the OC is not maintainable. Now here, a landmark judgment is in the case of Mobilox. Mobilox is again a must-read judgment by all of us, which talks about essentially a petition under Section 9 as to what all defenses can be taken, what all responses can be given, and what could be the view of the NCLT in relation to a petition under Section 9 in respect of which disputes are demonstrated by the corporate debtor. So depending upon what is made out, what is defined in Mobilox, you have to advise your client whether you are representing the case of the petitioner or the respondent. So before the petition comes up before the NCLT, the stage of reply to demand notice is there, which is very, very important. It's a foundation of the petition. I have come across matters where persons have lost or succeeded just on the contents of demand notice or the response to the demand notice. So the demand notice or the response thereto is a very important aspect, and it has to be taken care of with extreme caution, because the consequences of IBC, as you all understand by now, are very serious. So therefore, it is very important that the demand notice and so also the reply thereto not only has to be given in a time-bound period, but it has to be also appropriately worded. Now, therefore, a pre-existing dispute is something which is a direct defense available to a corporate debtor. Now, dispute can be shown by showing that, look, gentlemen, there's a suit already pending, filed by the corporate debtor, claiming something against the operational creator arising from same transaction, or pendency of arbitral proceedings. If not, any other proceedings, could be a winding up proceeding under the old Companies Act, could be any correspondence initiated demanding money, etc. All that would suffice for the purpose of showing a dispute under the IBC. And the law, as I said, is that if you are able to demonstrate a pre-existing dispute, then Section 9 or the proceedings under the IBC at the instance of an operational creator is not maintainable. So as a professional, you are required to examine the demand notice and the reply, which is very, very important, because your success depends upon the right advice to be given to your client at this stage. Now, as I mentioned to you, if demand notice is not replied, the petition can be filed under section 9 in form 5, and then the concerned NCLT can take the note of the petition and take the matter forward. It's the NCLT of the jurisdiction where the company's registered office is situated. For example, the debtor is in Ahmedabad, therefore you have to file a petition in NCLT Ahmedabad. If the company, respondent company, the corporate debtor is based out of Ahmedabad, you have to file a petition wherever the company is situated. So the NCLT having jurisdiction in respect of the registered office of the corporate debtor is the NCLT before which you have to approach. So I have also come across cases where for a company based out in Mumbai, petitions are filed in Gujarat, in Ahmedabad NCLT, and vice versa. So you have to advise your client, if at all there is a petitioner, about the place where the petition has to be filed. Next. Now, as I said, if you're able to show that there's a dispute in section 9 proceedings, then the application, the section 9 application, the petition before the NCLT is liable to be rejected unless you demonstrate that, suppose you are for the petitioner and respondent has raised some dispute. As a petitioner, you demonstrate that the dispute raised is a moonshine, is frivolous, is fallacious. So if suppose you are able to show that, look, the dispute being shown is completely fallacious, it has no relevance with this transaction. Now there we have a lot of judgments by now which have discussed as to what happens in a given situation where suppose dispute is raised by the corporate debtor, and even after the dispute is raised, the debtor pays some money to the OC. Then the law is, as per judgments of the various courts, that the dispute will not come in the way of the NCLT to entertain and admit the petition. Because even after dispute, you have paid money, meaning thereby the dispute is not genuine and it is moonshine. In any case, amounts are admitted because you have paid money, etc., etc. We also have judgment where the view taken is that suppose even after raising the dispute, you have given the checks and the checks have dishonored. There also the courts have taken the view that if you're given the check after raising some disputes, in such circumstance, the dispute is deemed to be not genuine. It cannot disentitle an OC to maintain a petition before the NCLT. These are the, so when you are a petitioner and you receive a reply, your client receives a reply to a section 9 application where disputes are raised. You have to see whether disputes are genuine or not. And to find that out, one of the features which you have to keep in mind is whether your client will receive any money after those communications raising disputes or not. If some money received by your client after the communication of so-called disputes, then you can certainly maintain a petition by pointing out that dispute is not genuine in as much as the person concerned, the respondent, has paid money, meaning thereby it has accepted the debt and therefore it has paid some money to you. Or you show any correspondence, even just email, any communication by which you can make out that the person admits to make more payments to you, etc. So dispute and thereafter, if some amounts are paid or assurances are given, email communications are there, in such circumstances, you can advise your client to proceed further and maintain the section 9 application. Limitation is universal both to a section 7 applicant and to a section 9 applicant. If your claim is time barred, then of course the petition is liable to be rejected. If the amount of default is less than 1 crore, today, earlier when the law came into force, the limit was 1 lakh, is now revised to 1 crore. So if the claim made by you is less than 1 crore, you can maintain a section 9 application.
So can I ask you a question, sir?
Yeah, please.
So if the demand notice is issued within the limitation period and the petition is filed after the limitation period, are they maintainable?
According to me, if the time gap is huge, for example, you are Hema, right?
Yes, yes, sir.
So suppose today you issue demand notice,
Right,
and within 10 days reply has to come,
right.
and you are entitled to maintain the petition after 10 days.
Yes, sir.
Suppose you don't file within 10 days, you don't file
Right.
the petition within reasonable time after 10 days,
Okay,
and you file after 6 months or 1 year,
right,
then you can't take the advantage of limitation.
right. But if it is filed within,
Reasonable time.
okay,
Yeah, if you do that, you can take
Yeah.
advantage of limitation from the date you issue demand notice.
okay.
Yeah.
Yes, sir. Thank you so much.
Pleasure. Next slide, please. Now, same is in the case of section 7. Documents have to accompany with relevant documents. Essentially, so far as section 9 is concerned, the judgments of the courts that you have to place on record the contract or purchase order. Could be purchase order is also contract, as you know. So a contract or an agreement or MOU or purchase order supported by invoices, delivery challan to evidence that the goods are delivered unless it is admitted from the record, and the bank statements. And if disputes are to be raised, you have to show that disputes, suppose you have a respondent and disputes are there, you have to demonstrate that there's a genuine dispute, and in support of the dispute, you have to show material, which material should be of a date prior to the demand notice. So any dispute which is post the demand notice date is not relevant for the purpose of showing existence of dispute. So you have to show that before demand notice, there was an exchange of correspondence between the parties, raising disputes about, let's say, quality, the quantity, delivery, and so on and so forth. If you are able to show that there has been correspondence between the parties before the demand notice came to be issued, then the petition under section 9 is not maintainable and is liable to be rejected. The courts have taken the view, which I'm sure you must have read, beginning from judgment of Mobilox, that the court is not to examine the genuineness of the dispute. So long as the dispute is seemingly plausible dispute, a reasonable stand is taken about the dispute, court doesn't decide the merits of the dispute. So a small distinction here is what is made out by the judgments, unlike our old Companies Act of 1956. If you recollect, some of you must have advised the clients in relation to winding up actions under the old Companies Act of 1956, where the law was that dispute, if at all you raise, it should be on merits maintainable. Under the IBC, a dispute simpliciter with plausible contents is sufficient to disentitle the petitioner to maintain a section 9 application. So as a petitioner, you have to only make out a case that the dispute is moonshine, frivolous, and as a respondent, you have to only show that there exists a dispute. We have had correspondence before the demand notice. We have raised disputes about the quantity, as I mentioned, or quality or payment or whatever. And it's a reasonable dispute, a plausible dispute is made out. Merits are not to be seen by the NCLT while examining a section 9 application. This is all about the dispute part. Next, please. Section 10 is very important, as I mentioned to you, for professionals like you, where, see, section 7 and section 9 is imposed initiation of CIRP. Somebody files, suppose you're for the corporate debtor. So section 7 applicant moves the court, a 9 applicant moves the court, and you suffer the insolvency proceedings. Here, the company itself can move the NCLT and seek its own resolution. It's a very important provision and enabling provision. It entitles your own resolution, which provision has not come across under any of the previous statutes. Very important, and it is used largely by the corporate debtors. Wherever they find that company can revive, company can resurrect, it can be resolved. So companies are coming forward now and they are wanting to have their corporate resolution. The advantage here is that you can plan your resolution. You can talk to the bankers because you are familiar with the IBC. The IBC gives a very important position to the lenders, the financial creditors, the committee, which is ultimately known as committee of creditors. So one can consult the committee of creditors, take them into confidence, and then initiate the action under section 10 and seek its own resolution. So in a 6 months time or a 9 months time, the company can revive completely with the assistance of the committee of creditors. So there are some requirements of IBC. So far as section 10 is concerned, rules are there. We should follow those rules. We can maintain an application. Next, please. Now, in section 10, there are some requirements, as I mentioned. The third dot, information, you books of accounts, etc. You name the IRP, pass a special resolution. You see, when the IBC was enacted, there was no requirement of special resolution. Later on, by amendment, the law has now stipulated that the company, before it files an application under section 10, it has to pass a special resolution resolving to maintain or to file this application under the IBC. Next, please. Now, we have discussed so far about what actions or precautions to be taken by a petitioner or by a respondent. And if you're advising the persons on either side, this is what you have to keep in mind as a professional. There's one angle under 29 capital A, which I would like to share with you. It's important because you may also have clients who would like to become resolution applicants. There are people who would want the company to be taken over by them and to become a resolution applicant. 29 capital A is very important provision. It is little, it requires some attention, it requires some reading, it requires some examination. Therefore, I have made a special reference to 29A. But it's very important provision, and when you are advising a resolution applicant, you have to understand this provision very carefully. Broadly speaking, I must tell you, share with you, that your client who proposes to be a resolution applicant, the applicant who wants to submit a resolution plan, to resolve the corporate debtor, that resolution applicant must not be ineligible under clauses A to I to section 29 capital A. 1. 2. Even persons who are connected to the resolution applicant, the persons connected is defined under the section itself. We have clause J, which defines persons who's connected. They must also not be ineligible under clauses A to I. So not only the resolution applicant, the persons who are connected to the resolution applicant also must not be ineligible under 29A. Third, persons acting in concert. We are familiar with SEBI law. We are familiar with SEBI regulations, which defines persons acting in concert. Now, a person acting in concert with that of the resolution applicant also must not be ineligible to be under clauses A to I. So please understand, it is just not the resolution applicant. Any person who is directly or indirectly connected to the resolution applicant must also be eligible under A to I to submit a resolution plan. If any of these persons were connected with the resolution applicant are not eligible, then the resolution applicant is also not eligible to submit a resolution plan. The object is that if the corporate debtor and the promoters are not eligible, the law doesn't permit the promoters of the corporate debtor to submit a resolution plan. So any person under the guise of the being a resolution applicant cannot come forward being a front person of the promoter to submit a resolution plan. So any person connected to the promoter directly indirectly must not come. Law has taken care to see that any person who's a defaulter must not come and submit a resolution plan. This is the object of 29 capital A. Next, please. Now we have so far discussed about the IBC. Broadly speaking, those are the three proceedings under which you can advise the clients. Then we have talked about the resolution plan, resolution applicant, eligibility thereof, and so on. Where, at the pre-petition stage, pre-initiation of proceeding stage, you can advise the client. So we have touched some relevant aspects of the IBC. Because of constraint of time, I have not examined or given details to you about other kind of proceedings under the IBC. Now I am going to the Companies Act. Some broad topics I will be touching here where, again, your role as a professional to advise a petitioner or a respondent may come in picture. So first is 241. 241, I'm sure you're aware, under the Companies Act, talks about a petition for operation and mismanagement. Now, the fundamental issue is who can maintain a person, a shareholder, having 10% of shareholding alone is entitled, either himself or along with other shareholders who in aggregate hold 10% and above. These are the persons who can maintain a petition, provided they make out a case of operation or mismanagement. Now, these persons, if they don't hold 10%, then we have section 244, which enables such a person. Suppose I'm a shareholder, I don't have 10%. I cannot derive support from 10% of the shareholders of the company to maintain a petition. In such a case, I can move the NCLT and seek a waiver of this requirement under the scheme of section 244 of the Act. And the NCLTs generally would like to support such an application and consider favorably, provided you can demonstrate that keeping in view the shareholding pattern is not just possible to get support of 10% of shareholders to maintain such an application. So these are the applications which can be maintained at the instance of a shareholder. As per scheme of various judicial pronouncements, an applicant should be a minority shareholder who is oppressed or who is prejudiced by the acts of the majority shareholders, or he can demonstrate that the company is prejudiced on account of certain acts of the majority shareholders. So these are the basic essential requirements which you as a professional should understand, that if suppose somebody comes to you, he wants to file a petition under 241. So you might have to see whether the gentleman or the person who has come to you holds 10%. If not, whether you can garner support of the shareholders who have 10%. And if not, whether you can maintain a waiver application on his or her behalf, and whether he is able to demonstrate that he is prejudiced, he is oppressed by the acts of the majority shareholders. A majority shareholder cannot come to you and ask that I want to maintain a 241 petition because the minority shareholder is causing prejudice to me, So that situation generally is not entertained by the NCLT, where a majority shareholder comes and seeks indulgence of the NCLT under 241 of the Companies Act. What precautions? Precautions generally is that if you are representing a person who is aggrieved by the actions of the majority members of the company, first is communications, representations. So you must put your grievance on record. So if you're advising a petitioner who is sufferer, who is a victim of the oppression by the majority, you must advise the client to send communications calling upon the majority shareholders to redress the grievances. You may also advise the client to write communications to the regulators such as ROC or the RD or the SEBI, as the case may be, pointing out your grievances and calling upon them to intervene and grant indulgence and find a solution. If not, order investigation, order inquiry, and so on and so forth. So there has to be a record. See, 241 is a kind of trial. It's not a small matter. It is a matter which involves a lot of evidence, a lot of issues, a lot of adjudication by the NCLT. Therefore, there has to be a material with you. We have judgments of Supreme Court taking a view that pleadings is very important so far as 241 action is concerned. You have to support your pleadings. Pleadings, I'm sure you are familiar. It involves both oral pleadings and written pleadings. So there has to be documentary evidence to support a petition. Therefore, your role comes in. You have to understand the law behind 241, see some landmark judgments, which we'll discuss later. And in the context of landmark judgments, you have to advise your client that what steps, what precautions, what documents should be in place before you maintain a petition. And then only you can maintain a petition. Besides, for what prayers you can maintain a petition is also very important. So for which, possibly one has to go through some landmark judgments and then advise the clients accordingly. Next, please. Now the compliances, as I mentioned to you, if you are a minority shareholder, you must insist on attending the general meetings. If you're a director, you must attend the board meetings, register your protest in the board meetings, ask for the minutes. If you're for the company, you must advise the company to circulate minutes to all the directors of the company, make all compliances. don't violate the law. And if you receive a notice from the ROC, respond to it. Notice from the shareholder to the extent permissible. Suppose a shareholder, in a given case, sometimes they demand many things from the company. You as a professional should find out as to what all responses, information, documents can be supplied under the Companies Act to an aggrieved shareholder. So you must restrict your answer to only those things which the law enjoins upon you, your client, to comply. So as a company, if you are asked upon by a shareholder to supply hundreds of things, you must restrict your answer to things which in law you're obliged to provide or part with. So it's very important that if you are for the shareholder, you must know what things you can demand, you must demand. If you don't demand, to file a petition will be a problem. So you must demand and make on record that, look, you have demanded, and also approach the regulator, that is the ROC, and tell them, despite my demand, these things are not being provided. If you are for the company, you must provide those information which you are obliged to provide. If you're not obliged to provide, don't give it. So these are the compliances which are necessary at pre-petition stage if you are appearing for either of the parties. Compliances, documentary evidence, record is very important. Next, please. This was on 241. 164 actions today are becoming very common. I'm sure you must have received many requests from clients, persons who were directors, who are directors, and who are being disqualified. See, the government has become very active in respect of defaulting companies. So companies which default in compliances in the form of non-filing of returns with the ROC MCA portal. So they are disqualifying the directors under 164, 167 of the Act. And they're also striking off the names of those companies as defunct companies and defaulting companies. Now, the provisions of 164, I'm sure we all must have read number of times. We can again go through. But the point is that you must make sure that your client who's a director in a company, that company should comply with the requirements of 164, 167. If your director is unable to make sure that the compliance are made, because in a given case, your director could be a professional, could be independent director, he cannot really make sure that the company complies with stipulation of filing the documents within the time as is stipulated in law. Then, according to my view, in case you want to avoid disqualification, he must resign from the company. Because once he's disqualified, he is disqualified from all the companies. And he can't use his DIN, he can't represent himself as a director of any company. So this is the effects of a disqualification action. And if you are disqualified as a director, you have to approach the High Court and seek an order. And that, is a judicial action which takes time to get the relief. Secondly, you also could be a part of the company of which the name is struck off. Again, you stand the chance of being disqualified. So the suggestion is that either your client make sure that the returns are filed, uploaded within time, defaults don't exist. Default of last 3 years is what is relevant for the purpose of facing the disqualification. If defaults are not made, you are safe. If defaults are there, either you make sure defaults are removed and the issues are rectified, or you resign before the expiry of 3 years, in which case you avoid disqualification. If you're disqualified, the remedy available to you is only to move the Honorable NCLT, Honorable High Court, and seek an action for removal of the disqualification. Next, please. Safeguards we have discussed just now, that there are the mandates of law, some requirements of the Companies Act, requirements of filing form, etc., rules, etc., are to be followed. The ROC has to give a hearing to a director before he is disqualified. That is the law, mandate of law. The ROC never hears, we understand, and it publishes a common list disqualifying large number of persons together in one go as directors. The law, as per the High Court judgments, have been that hearing is necessary, notice is necessary. If it's not done, you can move the High Court. But yes, you have to move the High Court by a writ petition and seek an order of setting aside the action of disqualification. Next, please. So again, on disqualification, the action is stipulated, just it's a procedural. The judgment of Madras High Court recently pronounced in October 2020, which talks about what steps a company has to take. Suppose you represent a company, and one of your director is a director of another company which is in default in filing returns. Then you as a company is required to file DIR 9 with the ROC. If you don't file as a company, you suffer the prejudice. So as a company, and if the company is under your advice, the company has to keep a tab on the directors and see to it that the directors of your company are not disqualified in respect of companies other than your company in not filing returns. So the directors of your company also possibly have to declare before you, the company whom you represent, that they are not disqualified, they are not in default in relation to filing of documents for other companies also. And if they are, then you have to file some returns here in this company also with the MCA portal. Next, please. So once, if at all, you are disqualified, as I mentioned to you, you vacate the office in all the companies where you are directors. So no, that's not one company. You become ineligible to continue as a director in all the companies where you are a director. So therefore, it's very, very important that you're not disqualified, you don't commit default, and if default is being committed, you rectify it. If you can't rectify it, you resign from one company to save your disqualification in all the companies. So advice that you have to give as professional to your clients is that if you are a company and of which there is some director and he is in default of some company, then he has to resign from that company before the default ensues into disqualification, so as to see that he doesn't get disqualified from this company. So there is a reason now to have an interaction with the directors and the company to ensure that disqualifications don't happen. Next, please. 59 of the Companies Act is parameter to section 111 under the old act. See, there could be instance where your client is a member, a shareholder of a company, and he finds that name of another person who is shown as a member in the company is not correct, is not right. So you can take an action now under the NCLT and seek rectification of the register of members. The section provides for the method and mode in which you can move the NCLT and seek a rectification. And even if your client, who's a member or a shareholder, his name is removed illegally, wrongly according to you, from the register of members, you can maintain an action under the Companies Act. Why I mention this provision is for the reason that the law before the Companies Act 13 came into force was that if there are disputes which are of civil nature in relation to a membership of the company, the law before 2013 enactment was that you have to file a suit. But the law is that for any grievance that you have as a member, either your membership or membership of another person, NCLT is the only forum. You are not supposed to file a civil suit. So unlike the law which was earlier in the context of the old Companies Act, where in case of serious issues, tribal issues, one had to go to civil court. So I have come across many suits filed by the members under the old act because of a judgment of Supreme Court in a matter named Ammonia. That judgment is now being discussed so as to mean that no, it would not be relevant for the purpose of the present jurisdiction under the Companies Act of 2013. Today the law is, if you have any dispute qua your membership or qua membership of any other person in relation to the company, you can maintain a petition under 59 of the Act before the NCLT, and the NCLT has all the jurisdictions, all the powers, decide all issues and bring about a relief that is sought for by your client. Next, please. Of course, you have to make out a sufficient cause to maintain a petition, either in respect of your membership or the membership of any other person under 59 of the Act. Next, please. One thing is very important, 59 doesn't talk about limitation as being applicable, but we have judgments of the NCLT taking a view that for a petition under 59 also, Limitation Act is applicable. And if you don't file a petition within 3 years of the date of the cause of action to maintain a petition, either in respect of your own membership or membership of any other person, then the petition under 59 is not maintainable. I must share with you that under the old Companies Act, we did not have Limitation Act being applicable. Under the new Companies Act, we have a special provision under section 430 of the Companies Act, which provides that Limitation Act is applicable in respect of actions to be taken under the Companies Act 2013. Next, please. This is the last topic, compromise arrangement. I have found a lot of chartered accountants associated in proceedings of merger, demerger, compromise, revival, and so on and so forth, which in one phrase, we define it to be an arrangement, scheme of arrangement, could be of any kind of arrangement. Most of you are familiar, but just to recapitulate your memory, you have to file the proceedings under the NCLT accompanied by memorandum articles, latest audited balance sheet, board resolution, scheme, consent affidavits. You see, under the old Companies Act, we do not have the term consent affidavits. Under the new Companies Act, particularly in relation to the creditors, we have section 230 subsection 9, which obliges you to file consent affidavits, not consent letters. So affidavits has to be filed of value of about 90% and above to maintain a request to seek dispensation of meeting of the creditors. CS certificate is mandatory. Certificate of Auditor 133 is mandatory. Valuation report is mandatory. SEBI, of course, in case of listed company is mandatory, which was even the earlier under the old regime as well. Next, please. Next slide. So process, of course, again, just to recapitulate, you have to have valuation report for the purpose of exchange ratio. The consents could be affidavits of consent letters. In case of shareholders, there's no need to have affidavits. Consent letters are sufficient. In case of creditors, when you seek dispensation, you need to have consent affidavits. Next, please. Certificate of the chartered accountants is very important. The CA could be statutory, could be internal, could be even outside the company who could give the certificate. Board resolution is very important. And once you file the petition, the court generally would issue notice to the RD, ROC income tax department, if you are a listed company, to the SEBI as well, and any other regulator who could be associated in relation to the company. For example, if RBI is involved, you need to also give notice to the RBI. If Competition Commission of India is involved for some reasons, you have to give notice to the CCI as well, and so on and so forth. Next, please. Next slide. The last slide is the view, the orders which the NCLT would make on the application. The NCLT would, the first stage, admit the petition, order notices to be given. Second stage, order for advertisement. And finally, after reports are received, depending upon the response that you have to give, it may ultimately grant sanction to the scheme. So this is all about today's presentation. Thank you very much. In case you have any questions, you're welcome.
So this is Hema Shah.
Yes,
and
please.
We do have some questions, sir. I'm
Yeah.
just a moderator. Quick, some few questions if you could
Go ahead.
give. Vikas Bhai has asked a query: what if any interest-free deposit is given to some dealership, etc., and subsequently that company goes under IBC? Whether this deposit should be construed as a financial or operational debt?
Interest-free deposit.
Yeah.
may not be treated to be a financial creditor.
Fine, sir. Sir, one more question.
Yeah.
Other members too can ask if they are having any, either in the chat box, or you can unmute yourselves and ask. So this question is regarding dispute, wherein, usually what happens is the payment terms are, say, 60 days, 90 days. Until then, nothing is raised. The moment you're sending the notice for the due payment, that time the company responds back stating that there is a dispute regarding the quality. So how do you handle this before issuing a demand notice, or should a demand notice straight away be issued? What would you advise, sir?
I would advise to give demand notice straight away.
Rather than responding to this email or communication?
See, normally, if email communication has been received by you before you have given demand notice, you must reply to it for sure. But
Right.
if no dispute has come to you, don't wait for starting a dispute from other side. You must give a demand notice straight away.
Right, sir.
Hello?
Members, any other questions you all are having?
Hello.
Yes.
Sir, I'm Darshan Patel.
Yes, please.
My query is with regarding a limitation period. Say a petition has been admitted under Section 9. As IRP, I'm verifying claims. And for the purpose of claim verification, whether I need to consider limitation period. That is first question. And sir, what about whether I am having, deposits with the other parties, that company, CD. So, sir, whether that CD, while claiming the collections, whether limitation period comes in.
Kwa, your first question, yes, you may consider limitation period as an IRP. What is the second question? I couldn't understand.
Sir, there are unsecured deposits given to certain companies. So while receiving back, while claiming that those unsecured deposits, whether limitation period will be applicable.
Certainly. See, as I mentioned to you, if you have a date of default and limitation, see, from date of default, limitation would start. So even in relation to deposits, if you have a default already in place, limitation, in short, limitation has to be considered.
Okay, sir. Thank you, sir.
So we have one more question from Anjali ji. How to deal under Section 10 when COC is delaying the process? That is on the part of RP. She asks if you could, give more clarity, Anjali.
I couldn't
Just
follow
a
the question.
Sir, under Section 10, whereby the RP needs to cooperate with COC, so if the COC is delaying the process and not cooperating, what are the steps which an RP can do to see that the CRP completes on time?
Move the NCLT and seek direction against the COC.
Directions are okay.
Against the COC.
Sir, against the COC. Okay.
Yes,
okay.
yes.
Yeah. Thank
See,
you, sir.
in law, please understand, you are not at the mercy of the COC. Once you are appointed as the RP, you are an independent person, right? So if COC is not cooperating, you can move the NCLT and seek directions.
Correct. Thank you, sir. Thank you.
So one more question. If supposing my client has supplied goods and the payment has become due, and he is sending a communication stating for the payment to be made, and the CD is not responding, and your demand notice is issued and the petition goes before, how can you prove that then debt is existing, apart from you mentioned about the invoices, the delivery challans, the e-bill or e-way bill, if all those things are getting attached, and if he's denying, does he hold any stand in the court, sir?
No, he doesn't, because see, no sooner you establish that goods are supplied and they are delivered and they are consumed, they're not taken back by you. It's end of it. See, we have judgments of the NCLT also, Hema, where the view taken is that if the goods are delivered and consumed by the CD, that by itself would establish that this is a default and petition should be admitted.
Right. So, and taking this question a little further, the goods are delivered, they are consumed, and when the demand is raised, he raises a dispute regarding the quality. Wherein even our invoice is mentioning, or even say our quotation is mentioning that if any dispute regarding quality, it should be brought to our notice, say within some stipulated period of 1 week, 15 days, whatsoever. So in that case, that dispute is maintainable, sir?
It is not. As an OC, you should succeed.
Okay, sir. Thank you.
Pleasure.
Any other questions, friends? So in that case, we would like to conclude. So I see a Hemash and an insolvency professional on behalf of Ahmedabad branch of WIRC of ICI. Propose a hearty vote of thanks to you, sir. It was so kind of you to touch upon each and every aspect of IBC and the Companies Act so minutely, including right from, what is a default, what can be termed as a default, a financial debt, a financial creditor, operational creditor, how we could advise, both these types of clients from the CDS perspective as well. And the Companies Act, including 29A, I'm sure we would, want you to have many more sessions at our branch, especially with respect to 29A, because that itself is a topic in detail, including the compromise and arrangements, sir. I again propose a hearty vote of thanks for enabling our members to take the first step and be future ready. Thank you so much, sir.
My pleasure. Thank you.
Thank you, sir. Thank you.
Thank you. Bye-bye.
Participants, we will be starting the next session in 10 minutes. So be tuned and we will start at 11:45. Thank you so much.